The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. Thank you for joining us today for Strategic Litigation, Forced Labor in For-Profit Immigration Detention Facilities. My name is Melinda Smith. I'm the Director of Partnerships for Freedom Network USA, which is the largest alliance of experienced advocates working with survivors of all forms of human trafficking in the United States. We're thrilled to present this webinar today in collaboration with our member and partner, the Human Trafficking Legal Center. I just want to take a brief moment to thank their team for pulling together the expertise for this discussion today. And I'd also like to first start us off by introducing our moderator for today's discussion, Sarah Bessel, staff attorney from Human Trafficking Legal Center, will be leading us through this discussion today. Sarah, would you like to go ahead and get us started?
Absolutely. Thank you, Melinda, and thank you everyone for patching into today's webinar. We're very excited for today's discussion. A few housekeeping tips before we dive in. The PowerPoint that you'll see up on your screen is available as a handout. If you look on your right-hand side on your toolbar, there's a drop-down for handouts, and you can see that there. We'll also be recording this webinar, so if you have colleagues or partners who are unable to attend today, please let them know that they'll be able to view a recording of this at a later date. We'll be hearing from three great panelists today, about 25 minutes each, and that will leave us with about 15 minutes of question and answer. Please hold all of your questions until the end Q&A, and please type your questions into the chat box, and we will make sure that the panelists see those questions. So today we're all here to talk about strategic litigation, specifically individuals held in for-profit immigration detention centers in the U.S. have begun to file cases alleging forced labor, unjust enrichment, and human trafficking. So today we'll be talking about the strategic litigation brought by these detainees and brought to you today by the litigators who are bringing these cases. A blanket note that all of these cases are live. They're currently ongoing litigation, so all of these are allegations at the moment. So we'll hear first today from Alex Levy, a senior staff attorney at the Human Trafficking Legal Center. Alex directs HT Legal's quantitative research on federal human trafficking cases and contributes to numerous reports and resources used by anti-trafficking advocates and attorneys nationwide. Recently, Alex authored the Human Trafficking Legal Center's fact sheet on human trafficking and forced labor in for-profit detention facilities, strategic litigation in U.S. federal courts. We'll next hear from David Lopez, a partner at Outen & Golden and the attorney in charge of the firm's Washington, D.C. office. David served as general counsel of the U.S. Equal Employment Opportunity Commission from April 8th, 2010 until December 9th, 2016, the longest serving general counsel of the agency. David successfully argued the Menocal v. Geo case, which we'll be talking about today, before the 10th Circuit Court of Appeals. And last but not least, we'll be hearing from Brian Lopez, staff attorney at the Southern Poverty Law Center. Brian is a staff attorney with the Immigrant Justice Project specifically, and prior to working at SPLC, he worked as a trial attorney with the National Labor Relations Board and a private workers' rights law firm. Brian is on the SPLC team that brought the Barrientos v. Core Civic case in 2018, and we're very excited to hear from all of the panelists about this new movement. So, Alex, would you like to take it away?
Hi, thank you so much. I'm Alex Levy with the Human Trafficking Legal Center, and what I would like to do is provide some background. Unlike Brian and David, I have not had the privilege of working directly on any of these cases, so I'm going to leave those, the sort of experiential and the detailed parts to them. But I would like to provide some background about the 13th Amendment and how this works kind of in the larger legal context. So the first thing I'm going to do is lay out the 13th Amendment and specifically talk about its exceptions. Talk about the extent to which those exceptions do or don't constrain the rights of different incarcerated populations. After that, I'm going to give an overview of the federal law against forced labor and the associated civil cause of action, which most of you are probably familiar with, but can't hurt to review. Then I'm going to talk about the ways in which the civil cause of action is being used by three different types of incarcerated people, or three types of what I call carceral contexts. Namely, those are jails, prisons and rehab programs, and then, of course, immigrant detention centers. And, of course, the other speakers will focus on cases in that third category. So I will leave that mostly to them, but I want to put that in context a bit. Okay, so we're on, yes, slide 3. Okay, so the 13th Amendment doesn't protect everybody. Punishment for crime whereof party is convicted, that's allowed. This is, and I want to break this down a little bit more. Can you go to the next slide, please? Okay, so first we have whereof the party shall have been duly convicted section. The first feature of this exception is that it only applies to people who have been convicted of crimes. That, of course, includes plea agreements, but it does not include people who are awaiting trial and, of course, civil immigration detainees. So, in other words, pretrial detainees and civil immigration detainees are protected under the 13th Amendment, and that makes these suits much, much easier for them than for people who are post-conviction, people who are in prison or sometimes in alternative programs. We'll look at briefly at some cases in which that were brought by people in those populations. So next slide, please. And additionally, this exception only applies to servitude that is required as punishment for a crime, meaning doesn't count if it's imposed for some other reason. For instance, we'll see if this being imposed to force people to pay off debts, that doesn't work. If it's an incident to imprisonment, also not allowed under the 13th Amendment. Next slide, please. All right, so this is the forced labor provision of the Trafficking Victims Protection Act, which was passed more than 130 years after the 13th Amendment. Now, Congress passed this law pursuant to two powers. First of all, there's the second section of the 13th Amendment, which allows Congress to pass laws to enforce the first section. And then there's Article 1, Section 8. Now, it's in the prison cases, it's arguably an important question whether this law is just a way of enforcing the 13th Amendment, or possibly whether it's actually broader than the 13th Amendment. That really opens the door to the possibility of suits brought by people who are being punished for a crime, if indeed they're protected under this law, and this law is more expansive than the 13th Amendment. Next slide, please. All right, this is the civil provision of the Trafficking Victims Protection Reauthorization Act. It was passed originally in 2003, but then later expanded to allow people to bring civil actions for any violation of Chapter 77, including 1589, which we saw on the previous slide, and prohibition on debt servitude. Next slide, please. Okay, so now I want to look at some of the specifics of how people are using 1595 to sue various entities and people involved in what I'm calling the carceral context. So broadly, by carceral context, I mean entities authorized by the state to physically confine people, and in some cases to subject them to involuntary servitude per the 13th Amendment exception that we talked about. So I'm dividing it into three categories. We've got jails, and specifically municipal jails. We have prisons where people go following conviction, and relatedly mandatory diversion programs where people also go following conviction as an alternative to prison. And then we have civil detention centers, namely immigration centers, which I will touch on, but mostly leave to the other speakers. Slide, please. Okay, so we just published, the Human Trafficking Legal Center just published a fact sheet outlining much of this material and providing an overview of the cases in these different categories. Next slide, please. Okay. So the civil trafficking claims against municipalities and individuals associated with local penal systems all allege variations on the following. The plaintiff would be arrested for something minor. For instance, having an expired tag, not wearing a seatbelt, something like that, would be brought to court and told that they had to pay a fine. Now, the plaintiffs in these cases are all indigent individuals who, when they were brought to court, said that they couldn't pay, at which point the court sentenced them to pay out their debts for a set amount of, to pay out their debts by going to jail for a certain number of days according to the amount owed. So for instance, one person was arrested for unpaid traffic tickets. The Montgomery Municipal Court judge told her that she owed $4,985. She couldn't pay, so the court ordered her to spend 1 day in jail for every $50 she owed for 99 total days. Now here's where the servitude part comes in. Allegedly, authorities would also tell these plaintiffs that they could pay off more of their debts by performing labor in jail. So this particular plaintiff was told that she could, quote, pay back $50 per day in jail, but she could pay off an additional $25 if she also cleaned the facilities and other public buildings. Slide, please. So Reynolds v. US was a case decided all the way back in 1914, and it involved something called criminal sureties. The way sureties work is that a person would be arrested and often sentenced to work on a chain gang. But a surety, in this case Mr. Reynolds, would come in to court and pay bail in exchange for a promise that the defendant would work on his plantation in order to pay back the debt. What this ended up facilitating, predictably, was a type of embedded servitude, something that Justice Day called the, quote, ever-turning wheel of servitude. And this kind of servitude, the court said in Reynolds, was anathema to the 13th Amendment and the peonage statutes, which were passed at the same time, and the court said it was not constitutional. So the bottom quote here is a quote from the court granting in part and denying in part the motion to dismiss in one of these cases, McCullough versus City of Montgomery. The court here is pointing out that the allegations here are exactly the same, substantively, as what was going on and what was held unconstitutional in 1914 in Reynolds. Next slide, please. So 3 of these cases are ongoing, 3 settled, and one thing I want to note is that at least one of the cases that settled involved injunctive relief that affects a lot of people. There was a significant overhaul of the municipality's bail practices. This brought a tremendous amount of attention and I think reform as a result of, excuse me, as a result of the civil lawsuit. Next slide, please. Okay. So now I've grouped the second category of cases together because they all present a similar challenge, which is that the plaintiffs have been duly convicted of crimes. So in theory, we are in the territory of the 13th Amendment carve-out. Now, in 2 of these cases, the plaintiffs alleged that they were sexually assaulted by guards or that guards allowed such assaults to happen. And in those cases, there's no allegation that the servitude, in this case sexual servitude, was as a punishment for a crime. So there's really no argument to be made that they are outside of the 13th Amendment's protection. 2 other cases were brought, and these are both ongoing, against alternative diversion rehab facilities. I'm putting those all into a sort of category. Next slide, please. This is an image of a facility known by the acronym CAAIR. It stands for Christian Alcoholics and Addicts in Recovery. Plaintiffs who brought suit against this organization were people who were convicted of a crime in Oklahoma and opted to go into a residential rehab program instead of prison. Now, they allege that that's not actually what happened. They opted for the diversion program, but they say they did not, in fact, receive any sort of drug rehab treatment, any sort of medical care, any sort of care at all, but were instead, they allege, forced to eviscerate chickens and to perform very grueling manual labor for no compensation for a private company. Next slide, please. Okay. Now, finally, there's a case against Geo Group. Brought most of the cases that were the other panelists are going to talk about are brought against Geo Group involve immigrant detainees. But there is one case that has been brought against Geo Group by prisoners. And this is the facility. This is a photo from Geo's website. And in that case, the plaintiffs have been convicted of crimes. And the plaintiffs there include more than 100 state prisoners with developmental and mental disabilities who say that they were held in what was called the mental health unit of the Geo Group's facility. And they claim that while the defendants claimed that they were going to provide treatment to individuals held at this facility, within this unit of the facility, that instead, allegedly Geo forced them to engage in labor. So this case is ongoing as well. Slide, please. Okay, so this is the outcome of those cases. The one case that settled was one of the ones where there was really not any sort of, there was no allegation that the servitude was as a result or as punishment for the crime. Next slide, please. Okay, this is an article about the lawsuit against CARE that brought on behalf of people who had opted into the residential rehab program. This is by Reveal. It's excellent coverage of this case. Next slide, please. Okay, and then finally we get to the cases against immigrant detention facilities. All the cases in this category are ongoing. And I guess I'm going to let the other panelists take it from here so that I don't step on any toes, and they've been involved in the cases, so they're better able to talk about them than I am. But I'm so I guess I'll leave it sort of on that hanging note. Happy to answer questions after the other panel.
Great, thank you, Alex. Thank you, Alex, so much. And so now to actually get into kind of go from that macro view now down into the weeds, our next speaker, David, is up.
Hi, thank you. It's a real pleasure to be here. I am going to talk about the case of Menocal versus the Geo Group. This is a very innovative, very important case dealing with allegations that a private prison facility, civil detention facility, violated the TVPA. The slides I am going to show are courtesy of Towards Justice. One of our co-counsels in this case, Towards Justice, is a nonprofit advocacy organization based in Denver, Colorado, that presses issues of economic justice and workers' rights. I'm on the board, but because I shamelessly plagiarize the slides, I want to shamelessly plug the organization. It's been a fantastic organization, and it's really been the energy of that organization that's driven this case. So let's start out with a very broad view of the case procedurally. Menocal versus Geo is a case that has two claims, and I'm going to go into more detail about the specifics of the claims in subsequent slides. But one claim is a forced labor claim under the TVPA, and the other is an unjust enrichment claim under Colorado state law. Originally, the class also alleged wage discrimination claims under Colorado state law, and those claims were dismissed. But what happened after that was very, very important, is that the district court certified the plaintiff class with respect to both the forced labor and unjust enrichment claims. That decision went up to the 10th Circuit. The 10th Circuit unanimously upheld class certification. Recently, GEO filed a petition for cert in the Supreme Court. Technically, discovery is ongoing. There are also ongoing efforts to resolve the case. I think it's important as I discuss the case to remember that this is a live case, this is a pending case, that we have not been able to prove yet any of the violations that we allege, but we have done very well procedurally, as I will discuss in the subsequent slides. Next slide. Okay, so as I mentioned, there are two policies, there are two allegations. There's a forced labor allegation and an unjust enrichment allegation. The forced labor allegation deals with a housing unit sanitation policy, and we're going to talk about that in more detail. But this is basically a policy that mandates who cleans up the common areas in the detention facility. The voluntary work policy is a policy that provides the detainees $1 a day for performing a variety of tasks in the prison. Now, what we talked about in the paper with respect to both claims that really kind of ties everything together is that there's only one paid custodian in this facility for what can be up to 1,000 detainees at any time. The other thing that's very important to remember about this case, as we look at it, is that this is a civil detention facility. These individuals are not in the facility because they have been convicted of committing any crimes. They are all in various stages of deportation proceedings, and they are being detained under civil authority. Next slide. Okay, so this is sort of, this case has generated a lot of publicity, a lot of attention, because it's really focused on the private prison industry. And the private prison industry, as many of you know, is a pretty controversial industry. And the past administration took one approach to private prisons. This administration has taken a much more bullish approach as to the necessity and funding of private prisons. But these are institutions that at the end of the day are focused on really maximizing value for the shareholders. And these are funded by the taxpayers, but really operated for the purposes of the shareholders. Next slide. So the forced labor claim is predicated on the TVPA. And I know that we talked about that already, but really the focus is whether anyone knowingly provided or obtained the labor services of a person by means of force, threats of force, physical restraints, or threats of physical restraint to the person or another person, by means of serious harm or threats of serious harm, by means of abuse or threatened abuse of law or legal process, or by means of any scheme, plan, or pattern intended to cause a person to believe that if that person did not perform such labor services, that person or another person would suffer serious harm or physical restraint. Next slide. Okay, so what happens here is that the detainees, this is a civil detention facility, but the individuals who are detained in the facility are really, as we argued at class certification, really under the complete control of the GEO facility. The GEO facility, as the minute that they show up, determines what they wear, where they live. They're deprived of their liberty, and they're under the control of the facility. The facility has various disciplinary measures that it takes against the detainees for various violations. And so what we allege in this case is that the detainees are forced to clean under the threat of solitary confinement in violation of the TVPA. How does this work? Let's go on to the next slide. Okay, so it's important to remember that this claim is a claim of forced labor. So every day under the housing unit sanitation policy, 6 detainees are required to clean the facility's pods, the common areas, without any compensation. So that means the detainees are cleaning common eating areas, toilets, and showers. And the backdrop of this work is really an understanding that at the end of the day, if the workers do not perform this work, they will face discipline, including solitary confinement. There are 2 different types of solitary confinement. There's administrative segregation and there's disciplinary segregation. Disciplinary segregation means that the detainee is basically kept in a small cell for 23 hours a day. And so what we allege is that is a violation of the TVPA, that the individuals are in essence being forced to work by the company as a cost-cutting measure. And so, you know, in the class certification record, there were declarations submitted about detainees and threats by guards to send the detainee to administrative segregation or solitary confinement if the detainee did not complete the work. And of course, the general understanding we believe and will prove up at trial is that the detainees certainly understood that any infraction of the rules of the facility could ultimately result in solitary confinement. Next slide. Now, this case has been covered as a forced labor case, but it's also generated a lot of publicity for the second claim. That's the $1 a day. And somewhat ironically, I think initially the $1 a day claims generated much more attention. And, you know, I think when we jumped into this case, we found that interesting because, of course, the solitary confinement claims basically allege that the individuals are not paid at all, but instead are coerced into doing work. But let me talk about the $1 a day claims. Next slide. So the $1 a day claims are brought pursuant to the facility's voluntary work program. The voluntary work program basically is a program that was set up by GEO that allows detainees to do a variety of tasks and get paid $1 a day for those tasks. Next slide. And so these tasks are all tasks that are central to the operation of the facility. They include laundry, preparing meals, cleaning, maintaining the medical facility. And so the detainees will work, you know, 4, 5, 6 hours a day, but will always be paid just $1 a day. Now, ICE requires, you know, this contract between the facility and ICE. So ICE requires that the voluntary work participants be compensated for at least $1 a day. But it's our allegation that ICE does not set any maximum, and that that GEO has the discretion to pay the workers more, pay the detainees more. GEO says, look, we're limited to $1 a day. That's all we can pay under the governmental contracts. So that's a big issue that if this case is litigated further, will have to be duked out. But our allegation is that GEO is able to pay the detainees more, but chooses not to as a cost-cutting measure. And again, I think one of the facts that sort of drives this home in terms of what's going on here is the fact that GEO employs only one outside custodian to maintain the entire facility. Next slide. And so this case was brought as a Rule 23 class action. As I mentioned, the two classes were certified, and the appellate court affirmed the certification unanimously. So the forced labor class, we believe, consists of between 50 and 60,000 people. These are all civil detainees detained at the Aurora facility since 2004. The unjust enrichment class, this is the $1 a day program, we believe consists of between 2,000 and 3,000 detainees, the individuals who participated in this program. Next slide. Okay, so as I mentioned, the last major procedural event in this case was the 10th Circuit's affirmance of class certification. For those of you who do Rule 23 class actions, you understand that the class certification component of a case is critical. Recently, as I mentioned, GEO filed a petition for cert to the Supreme Court. Right now, there's a stay in discovery to talk about settlement. So right now, everything is in flux with this case. But I think the important takeaway from this case going forward, and there are other cases like this which have been brought around the country, is that the TVPA could be a very, very important statute in terms of addressing the conditions of detainees in private facilities. As I mentioned, my law firm got involved in this case after it had been filed and after the initial class certification proceedings. This case was brought by a number of attorneys in Colorado, just a wonderful group of attorneys, but really at the hub of this team is Towards Justice. And Towards Justice, as I mentioned, is an advocacy group that presses issues of economic justice and workers' rights. So definitely feel free to give me a call about the case. I argued the appeal. I'm very steeped in the facts of this case. I'm very steeped in this issue, but definitely always consider using Towards Justice as a resource on these types of issues. So I think
Great.
I'm done.
Thank you so much, David. Next up is Brian.
Hello, everyone. So unlike David's Menocal case, the case I'm working on, Barrientos v. Civic, is in its very beginning stages litigation. We're awaiting an answer or motion to dismiss in the next week. We have not engaged in discovery yet, so much of what we know comes from interviews with detained folks at Stewart Detention Center, from Open Records Act documents, FOIA productions, and OIG reports. The Department of Homeland Security Office of Inspector General, which has issued reports on the conditions of Stewart Detention Center in Lumpkin, Georgia. Next slide, please. So because my case is such a preliminary stage, I kind of want to provide some context as to the way that these forced labor cases developed as a framework in immigration detention and detainee labor, the role of detainee labor in kind of a broader history. So as noted by my colleagues here, immigration detention is civil detention. It's generally only permissible as a means of preventing flight or protecting against danger to the community. But even though it's classified as civil, the conditions of confinement are usually pretty indistinguishable from those of criminal incarceration. And in the grander scheme of things, like prison labor's deep-rooted history in institutional slavery, detainee labor is really just the latest embodiment of a tale as old as time, which is, the United States need for cheap labor while sort of maintaining an underclass or failing to provide rights to those that provide the labor. So going from indentured Chinese laborers and then, denying those rights of indentured Chinese laborers and then excluding them through the Chinese Exclusion Act from, the 1880s until essentially the 1970s. Then Mexican workers in the Bracero program from the 1920s to the 1960s being used, to undercut domestic wages, break strikes, impede union organizing. And then the latest kind of iteration in the 1980s, the Immigration Reform and Control Act, providing that, it's illegal to knowingly hire or recruit undocumented workers. So although this law, the Immigration Reform and Control Act, prevents employers from hiring undocumented workers, the federal government is still benefiting, or private detention companies and the federal government seem to be benefiting through the advocacy of these private detention companies that allege that they're sanctioned to use undocumented labor for little to no pay while detained under the authority of ICE. Next slide, please. So over the last 3 decades, immigration detention has expanded about 8-fold. So that's 5,500 detention beds in '94 to about 41,000 last year, or more than that today, probably. A large part of this is arguably tied to the rise of for-profit prisons like CoreCivic and the GEO Group, who have spent millions of dollars on lobbying and campaign contributions. Indeed, in 2009, these lobbying efforts led to a congressional appropriations law requiring ICE to maintain 34,000 immigration detention beds on a daily basis. This has steadily increased its establishment, but at least to my knowledge and everyone in my organization, no other law enforcement agency is subject to this type of statutory quota on the number of individuals they have to hold in detention. So private prison companies now house more than half of the nation's detained immigrants, compared to about 25% a decade ago. CoreCivic, the defendant in my case, their total revenues in 2017 from all their private prisons were $2 billion from private detention centers where ICE is designated as its primary customer, accounted for about 25% of that. So that's $444.1 million in 2017. Next slide, please. So a large part of how these private detention centers seem to be able to maintain such high profits and are able to spend such large amounts of money on their lobbying efforts is due to its business model. Private detention center business model is built-in savings through the utilization of free or low-cost labor from the immigrants that they detain. So a 1950 law created the Federal Voluntary Work Program and set the pay rate at the time for $1, which went much further than, the equivalent would be, the equivalent of the purchasing power parity today would be about $9.80. In 1979, Congress last reviewed the rate and opted not to raise it at the time. ICE issued guidance incorporating into its contracts to detain immigrants that provides for this so-called voluntary work program. And I think as of 2014, the last stats were that 55 of the roughly 250 detention facilities used by ICE have some sort of voluntary work program. Of these, local governments operate 21 of them, and private companies operate the rest. And so essentially, one of the kind of catch-22s here is that the government, which forbids everyone else from hiring undocumented workers, is essentially become the single largest beneficiary of undocumented labor, while permitting itself and private companies to be subsidized by this labor. Next slide, please. So why aren't folks paid at least a minimum wage under this program? There's a decision in the Fifth Circuit, Alvarado Guevara v. INS, which the factual circumstances were detained immigrants working on this voluntary work program challenged their $1 per day pay at the Port Isabel Detention Center. The Fifth Circuit held that the twin aims of Fair Labor Standards Act would not be met by the protection of detained workers because their living standards and their well-being was being provided by the detention center. Much of the legal precedent relied upon by this court involves cases denying Fair Labor Standards Act protections to incarcerated labor in the criminal context. Much of those decisions deny FLSA protection because the work in the incarcerated labor was either part of the sentences to hard labor or served criminal justice's purposes of rehabilitation and punishment. So the kind of underlying reasoning upon which this decision is built is significantly flawed as applied to immigration detainees. Next slide, please. So these are the existing cases and the different geographical locations where they are taking place at. So many of these cases involve similar claims to David's case, to Menocal, but they all have slightly differing versions as to how the voluntary work program operates. Similarly, many of these cases have additional claims that are specific to certain state laws available to folks in those detention centers. So California and Washington, I think, both have state minimum wage law claims. I believe they were dismissed in the Menocal case, the state minimum wage law claim, and then other state tort quasi-contract claims and state versions of the TVPA in California. Next slide, please. So in my case, in Barrientos, we're dealing with the Stewart Detention Center. It's located in Lumpkin, Georgia. So here, the kind of structure of the parties or the players is, ICE commonly uses a type of agreement called an intergovernmental service agreement to reserve space at detention facilities owned or operated by state or local governments. Generally speaking, ICE has used state or local governments as middle entities to contract with private prison companies. And at least, I believe there's an OIG report from either early this year or last year that found that this sort of structure essentially circumvented federal procurement guidelines. So may be part of the reason that they developed this sort of practice. At the Stewart Detention Center, I entered into an IGSA with Stewart County, Georgia, for the detention of immigrants. Stewart County then contracted with CoreCivic to fulfill its obligations under the IGSA with ICE. And to kind of give you an idea of this one-sided relationship between CoreCivic and Stewart County has the highest poverty rate among all Georgia counties. Nearly 40% of the families live below the poverty line. The average unemployment rate in February of 2018 was 1.2% higher than the national average. Under the last IGSA, Stewart County is supposed to be paid $62.03 per detained immigrant per day by ICE, but in the last contract available to us shows that of that money, CoreCivic Stewart County only receives 85 cents of that and pays the rest to CoreCivic. The revenues from CoreCivic for 2016 from Stewart Detention Center were about $38 million. Stewart County's revenue from Stewart Detention Center that very year was $589,052. This IGSA also incorporates wage determinations under the Service Contract Act, which provide that service workers, most of them being positions currently worked by detained immigrants, are supposed to be paid prevailing wages above the minimum wage and additional benefits as well. Next slide, please. So as touched upon by my colleagues, the 13th Amendment prohibits involuntary servitude, provides an exception for those duly convicted under criminal circumstances. So why doesn't this necessarily, or why hasn't this been applied more forcefully as to civil immigration detention? So the TVPA's forced labor provisions legislatively were actually amended in response to decisions limiting the definition of coercion under involuntary servitude. And that limitation was that essentially the coercion in order to meet the 13th Amendment standard was physical threat or injury or threat of coercion through the legal process. So the forced labor amendments actually brought in the coercion element to include threats of physical restraint and serious harm. And serious harm is fairly broad, including psychological harm as well. In addition to that, part of those amendments were provision Section 1394, which also made it unlawful to attempt to commit any of the prohibitions in Title 18, and that would result in the same remedies as a completed violation. So even attempted forced labor is unlawful under the TVPA. Private detention centers have argued that courts should read a civic duty exception into the TVPA's forced labor provisions, as they have into involuntary servitude cases. I think most of the responses or the motions to dismiss that I've read point to Channer versus Hall, where the Fifth Circuit held that a detained immigrant forced to work in a kitchen under threat of solitary confinement was not subjected to involuntary servitude in violation of the 13th Amendment. Under this so-called civic duty exception, the civic duty exception provided that the government may compel people to perform communal contributions in the form of housekeeping tasks and not violate the 13th Amendment's prohibition on involuntary servitude. But as we've seen in the last 4 years, these lawsuits that have been filed, by folks that allege they're victims of forced labor at the hands of these very two large private detention center operators. Next slide. Complementing many of these claims, these forced labor claims are also unjust enrichment claims, as touched upon by my colleagues. So I'll just move to the next slide. So our case is a little different from Menocal in that we're not aware of anyone that is not compensated for their labor, but our essentially claim under the TVPA's forced labor provisions is that this is kind of a cohesive scheme. So detained immigrants held at Stewart Detention Center are deprived of certain basic necessities like hygienic products, adequate food, soap, toilet paper, things like that. In addition, in order to essentially afford those things, they need to enter this work program in order to be able to actually buy things from the commissary to supplement their basic necessities. Once they're actually in the work program, they are threatened with solitary confinement if they do not want to continue participating in the work program. In our case, additionally, it's not just threats. We have a named plaintiff who was actually placed in solitary confinement for allegedly attempting to incite a work stoppage. So he was placed in solitary confinement for about 10 days. He actually opted to voluntarily deport to stop continue fighting his asylum case due to the conditions at Stewart Detention Center. On top of that, other threats that we allege are essentially there's a sort of preferred housing for workers, for certain workers, and if they do not continue working, they're threatened with being placed in housing with worse living conditions. Next slide. So in our case, some of the kind of factual circumstances or alleged factual circumstances as to what we've been told by folks detained there and corroborated by some of these Office of the Inspector General reports are involve one, the housing. So most low custody workers, so these are workers that are classified as not, being dangerous or not having had prior convictions or charges against them are placed in open dorms. These open dorms have about 66 people in them. They are referred to by them as El Gallinero, which translates to the chicken coop. So these are open dorms with 66 people sharing 3 to 4 toilets. The showers, as alleged by our clients, do not have any temperature control, so only hot water comes out of these showers. There is no private space such that if there's ever any conflict, there's no space to retreat to, leading to a higher incidence of conflict and fights. Essentially, the conditions are such that these 3 to 4 toilets shared by so many people kind of the smell and the conditions emanates across that open dorm, making it very uncomfortable to live in. People that participate in the work program, particularly those in the kitchen, are provided the option to live in a dorm that has 2-person cells with one shared toilet with a cellmate. It has a common area. I forgot to mention this, but the open dorm is also alleged to have 24-hour lighting, such that one of our clients told us that he wraps a sock around his eyes in order to sleep. So in the preferred housing, the 2-person cells, they can turn off the lights and essentially retreat to a private space if there is conflict. In addition to that, those working in the kitchen program have told us that they've informed kitchen supervisors of spoiled and expired food, but have been told to continue serving it. People report getting ill from that food. Our clients allege that they have to supplement their diet by buying food in the commissary. A FOIA production released within the last 2 weeks has some mention of a detained person in a pod stating that the 88 people in his dorm mostly eat commissary items, and there's only 2 microwaves for those 88 people, leading to long waits to be able to eat. Denial of hygienic products. So our lead plaintiff, Mr. Barrientos, he reports that he ran out of toilet paper previously and requested another roll from a court civic officer. The court civic officer told Mr. Barrientos to use his fingers to clean himself. OIG reports state that there are long wait times for necessities like toilet paper. Detainees at this facility are not being quickly provided, or sometimes not at all provided. Supplies like toilet paper, shampoo, lotion, toothpaste. So in order to supplement those basic products, they work, they buy things from the commissary, which is essentially a situation by which they're being paid to give back the money to the Stewart Detention Center. They're buying products like soap and deodorant. We've been told that the cost of these things can run up to $4 for a stick of deodorant and soap. There's certain foods available. Many folks that we've spoken to have told us that the main things they end up buying are, cup of noodles, tortillas, and I think some canned foods were mentioned to us as well. All service work in the detention center is performed by detained immigrants. Only guard work is paid work by CoreCivic directly. So this includes cleaning of the pods and common areas, cooking for the 2,000 detained persons in the facility, laundry, barber work, dishwashing. All of that is done by the people detained at Stewart Detention Center. None of this is done by a direct employee of CoreCivic. Payment ranges from $1 per day for pod cleaning and to about $1 to $8 per day for kitchen workers. Kitchen workers have told us that you have to work 12 or more hours to be able to obtain the $8 rate. So there's a structure of if you worked up to 6 hours, you made $1. If you worked up to if you worked 6 hours or more, you made $4. If you worked more than 8 hours, $5. If you worked more than 12 hours, then $8. Additionally, the CoreCivic Steward Detainee Orientation Handbook, which is provided to everyone when they first arrive there, categorizes encouraging others to participate in work stoppage or refuse to work as a high offense category, which has a written policy of being punishable by initiation of criminal proceedings, disciplinary segregation of up to 30 days. And there's a report in the Intercept from last year where a Haitian detainee was held 30 days in solitary confinement or disciplinary segregation, as they say, for 30 days for allegedly inciting a work stoppage. Another potential punishment is the loss of privileges, so the loss of availability to commissary, to movies, to recreation, changing their housing, so the threat of being in this preferred worker housing and going back to the gallinero, and restriction to the housing unit itself. So this kind of begs the question that if there's a written policy providing for punishment for refusing to work or for participating in a work stoppage, then how can this work be voluntary? I think that's all I got for you folks.
All right, thank you so much, Brian. A reminder to everyone as we go into the queued question and answer phase to please type your questions into the toolbar. So the first question, Alex, do any of the cases that you've analyzed include labor outside of a jail? So for example, community service? Alex? Okay, so,
Well,
oh, there you are, okay.
I'm so sorry. That's a good question. The cases involving the rehab facilities or the diversion program facilities are technically not on prison grounds, right? Those are residential facilities, but they are not, to my knowledge, I don't know of cases in which detainees or prisoners are sort of outsourced off campus, so to speak.
Okay. And then another follow-up question for Alex. For the prison cases with the sexual misconduct, were those brought under the sex trafficking claims or were those forced labor claims?
They were brought, I believe, under 1591, so for sexual servitude.
Great. Thank you. And then just a general question for all of the panelists. Now that Attorney General Sessions is criminalizing anyone who crosses the border, will immigrant detainees be catapulted into the exception of the 13th Amendment? Do you foresee that happening?
This is Brian. So, that might be possible while they're being detained under the criminal aspect of that, under the illegal entry aspect. But once they're in immigration detention, folks have by that point have served their sentence, or have essentially gotten rid of whatever their sort of responsibility to own up to their crime has been. So yeah, there are folks in immigration detention that have been previously convicted of certain crimes, but by the time they're released to the custody of ICE, they have served their sentence. So as far as immigration detention is concerned, I don't think that exception would be applicable.
Yeah, can I add to that? No matter how many more things that are criminalized, the distinction is still before or after conviction. So if it becomes a crime or more serious crime to cross the border under XYZ circumstances, you still have to be convicted of that crime, even if the pool of defendants is larger. So no, I don't actually think that will make a difference.
Okay, great, thank you. And then David, a question for you. So the cert petition that was recently filed in Menocal claims that people were not coerced, but they actually do the work because they're either bored or they want to do their civic duties. So what's your response to that claim?
Yeah, I mean, I think that's an argument that's been raised from the district court level to the 10th Circuit level. I think that 10th Circuit addressed it very well, in my humble opinion, by noting that that you can't really rely on hypotheticals to defeat class certification. So they went in there and said, look, people may be working because of, because they want to work, or because they want to hang out with their friends, or because, this reason or that reason. But even though there was an opportunity to conduct discovery in this case, they actually did not identify one witness to come forward to say that anybody worked for those reasons. And so the court said, look, that might be an argument, that might be a way to defeat class certification, but you can't do it based on just speculation and hypotheticals. And then jumped off from there to say, look, the disciplinary policy was basically working as intended, right? I mean, the reason they had that disciplinary policy was because they wanted people to actually because they actually wanted people to follow the rules. And, with respect to the sanitation policy, they wanted folks to basically, clean the common areas without any complaint or without any pushback. And so the court looked at that as sort of being the central policy, and then drew an inference of causation, basically that the policy worked as it was designed to work, right? That the disciplinary policy was designed to make sure that people follow the rules, and that people follow the rules, because of the disciplinary policy. But I think that, the whole issue with respect to hypotheticals was addressed by the 10th Circuit. And, it was something that was really, I think, at the center of, I think, the oral arguments and the decisions in that case. So whether you agree with it or not, that's one thing. And, whether the Supreme Court agrees with it or not, that's one thing. But I think that the issue was vigorously pushed before the 10th Circuit by GEO and rejected by the court.
Great, thank you, David. And audience, thank you again for your great questions that are coming in. Please remember to put them in the chat box. David, a follow-up question. The other argument in the cert petition is that GEO is just following DHS rules. What do you say to that?
Well, I mean, I think that the cert petition again raised arguments that were raised in the 10th Circuit. So, I mean, I think right now, in terms of how we would respond to those arguments before the Supreme Court, I really can't go beyond sort of referencing back the 10th Circuit discussion about that.
Okay, great. Alex, a question for you. So you had mentioned a case, one of the cases ended in injunctive relief. Are we likely to see that occur in other cases? Why just that one case?
So the one case, I can't speak to why it hasn't happened in more cases. The case in which it happened involved allegations of a range of abuses, including, of course, the peonage claim, but the creation of debtors, prisons, other problems like that really called for a comprehensive reform of the municipal justice system. So I think a lot of the injunctive relief had to do with those kinds of systemic problems. They established oversight requirements, for instance, in that case. So I think those particular facts and allegations lend themselves to that kind of relief. I don't know, I guess I don't know exactly what it would look like under different facts, but I do think that it's a very powerful idea that sort of system-wide reform can come about because of someone filing a civil suit, especially under Trafficking Victims Protection Act.
And is that something that the plaintiff pushed for, or is that something the court just did sua sponte?
No, I believe they asked for injunctive relief. I'll have to check on that, though.
Okay, great, thank you. And so then just another question, either I guess Brian or David might be the best ones to answer this, but why now? David, you mentioned that one of the classes goes back to at least 2004. So what's brought this on, or is this just, as the defendants in the cert petition say, just a proxy war against the federal immigration policy? I guess I threw that out to both Brian and David. So.
I mean, Yeah, I mean that question has different layers. What brought it on is that I think that the lawyers, my colleagues who brought this case, believe that there was a violation of the law and that they had people come forward and raise issues that they believed reflected a violation of the TVPA and of Colorado unjust enrichment claims. Whether it's like I really don't understand the claim that this is a proxy war on federal immigration policy. I think we understand the TVPA as being grounded in the 13th Amendment, and that prohibitions against forced labor certainly precede this administration.
Great, thank you. And then for Brian, so you had talked about the Fifth Circuit's language about how there was really no impact on the detainees' well-being, and now all the allegations of them being threatened with solitary confinement. So in moving forward, how are you going about proving the serious physical and psychological harm under the trafficking statute?
Well, I think that as far as our plaintiffs are concerned, the threat of solitary confinement, the threats of being placed in more dangerous living conditions, the actual placement in solitary confinement, such that that named plaintiff, the one that was held in solitary confinement for 10 days, opted to go back to his country where he is part of a minority political party currently being, hunted down, would opt to be there rather than continue being in Stewart Detention Center, allegedly, is an indication of how severe that psychological harm can be.
Great, thank you. And I see some people typing some questions. Do we have any other questions coming in? Okay, here's one. So for David and Brian, for those, are there opportunities to participate? So for those in the participants on the line who are interested in participating, are there opportunities to submit amicus briefs? Are there other ways to get involved?
Well, I'll say that in the Menocal case, that case generated just an enormous amount of attention and participation from the advocacy community. So there were 4 amicus briefs that were filed by various organizations on various issues, including, the Southern Poverty Law Center, the National Immigration Justice Center, NELP, just a variety of different groups that were weighing in on the various issues that were raised in the case. So yes, certainly at the appellate level, not only were there opportunities that were taken advantage of by the various advocacy groups. I think sort of moving forward, I think one of the most important things, and I think Brian would agree with me, is just to sort of be the eyes and look for just sort of understand the paradigms that we're discussing and look for opportunities or look for other examples that, might fit within those paradigms, or look for things in the detention context that really kind of raise your eyebrows as sort of being unjust. But it certainly, as I mentioned in Menocal, there was enormous participation at the class certification stage. I mean, I think one thing that I need to really kind of emphasize, given that this is live litigation, is that the 10th Circuit case was about class certification and not about the merits. The petition for cert, though, GEO might signal some defenses that it wants to raise and that we may think are not legitimate. The petition for cert deals with the decision on class certification. And the idea is that, once a class is certified, then you start working it up as a class case for trial, where the merits would be the center of the attention.
Yeah, and I want to add that on a different level, in the legislative arena, a few different Republican congressmen have submitted letters to the Department of Labor, to ICE and DHS, essentially asking them to get involved in these cases or to involve or to respond to these cases by clarifying that, one, the Fair Labor Standards Act does not apply to detained workers, or amending the TVPA, or searching for or going forward to advocate for amending the TVPA. And Congressman John Lewis just sent another letter to these agencies as well recently in the last week or so, kind of providing a counterpoint to that. So I guess keep an eye out for your local congressman supporting these private detention centers' legislative efforts to combat these cases.
And that's a good segue into the next question. So, Alex, you kind of have the 3,000-foot view of all of this. So, as prisons and detention facilities are privatized, would it be possible for an ombudsman to be created to look at this issue nationally? An ombudsman that may have a power to have surprise visits and protection of individuals who are whistleblowers.
Yeah, I don't know a whole lot about the sort of follow-up procedures to make sure that any sort of entity or institution is complying with a court order. I think sort of what we're focused on, the important part right now, is actually getting through the litigation, establishing the facts, establishing people's rights, and then how to sort of put that into effect afterwards. I just don't know. And
David and Brian, have you considered injunctive relief as part of your strategy, or have you considered, you know, as a side advocacy strategy, raising this type of issue of a potential ombudsman?
So in our case, we're alleging a B2 and a B3 class. So we are seeking injunctive relief. I'm not sure how, what the role of an ombudsman would be in a victory for that. But as far as current oversight, DHS Office of Inspector General is well aware of many of these issues, and there hasn't been a reaction. So I'm not sure how useful the current oversight that exists is.
Yeah, and as a general matter, coming out of the ESC and a public enforcement background, I think an ombudsman or a monitor can be very effective in terms of ensuring on a day-to-day basis that the injunctive relief is carried out on the ground. So, I don't really want to comment within the context of the Menocal case. Certainly, as a general matter, that is often a very critical measure.
Well, great. Thank you so much, everyone. I think that's about as good a place as any to end. We're a little bit early, but I think that's about all the questions that are coming in. So a big thank you to Alex and David and Brian for really diving deep into this new and fascinating movement. Again, as we mentioned, this is a recorded webinar, so if you'd like to come back and watch the reruns, you're welcome to, or hand it out to your friends. And the PowerPoint will be distributed after. Of course, if you have any follow-up questions that you weren't able to get to today, please, you can follow up with the panelists. Any last words, Alex, David, or Brian?
No.
All right. And also, in terms of, Alex had referenced the report that she and HCLC recently published. We'll send that out as well as in a resource. Thank you, everyone, for patching in. Thank you, big thank you to Freedom Network, again, for hosting, and the panelists for presenting today. Everyone, you have a great day.
Thanks.